and succeeding generations to suffer the incalculable and irreparable injuries caused by the egregiously erroneous, politically motivated, and biased decisions of these unfit judges. And Elena gave everything she had to go down to protect you from that. Whereas we believe that the First Amendment is dead. When a patriotic, law-abiding, and dedicated American like New Yorker Elena Ruth Sassower, nationally recognized judicial reform advocate and co-founder and coordinator of the Center for Judicial Accountability Incorporated, a national nonprofit, nonpartisan organization working for years to ensure that only the best qualified lawyers become and remain judges, is arrested, incarcerated, and serving a 6-month prison sentence in a jail in our nation's capital for disruption of Congress. How can you be accused of disruption of Congress when Congress isn't even in session? As you saw on TV on a chat with Glendora through George McDermott, Chambliss had put the gavel down. It was over. Congress was not in session. And that's when Elena rose respectfully. Respectfully. And made her request to protect Americans from this man, Richard Wesley. All this for speaking out to protect the public interest in the integrity and impartiality of our judiciary. Her wrongful sentence was vindictively ordered to begin forthwith, i.e., on June the 28th, 2004, the very day of sentence, so as to ensure that she celebrated the 4th of July weekend in the D.C. jail. Yeah, that's something. On the birthday of the Declaration of Independence, because she spoke out to protect the public interest, she was put in jail. And so on the 4th of July, she's celebrating the independence. With her release not due until Christmas Day, from the 4th of July to Christmas Day. I'm just going to show you again Elena's picture. I've been a friend of Elena's, for maybe 12 years. There she is, great American hero. There she is. And she writes beautifully, too. She's a great writer. Whereas this totally bogus charge was based on Ms. Sassower's having respectfully asked the following question at a May 25, 2003 U.S. Senate Judiciary Committee public hearing. If it's a public hearing, why isn't it public? To confirm a number of President Bush's nominees for lifetime, you understand now, federal judgeships, including New York Court of Appeals Judge Richard Wesley, who was being nominated to the Second Circuit Court of Appeals. Now just let me tell you that Elena stood before Richard Wesley and the 6 other judges on the New York State Court of Appeals with a very important and significant and vital case. And she caught Wesley and the other judges lying. They lied. Judge Richard Wesley, who was being nominated to the Second Circuit Court of Appeals, including New York, Connecticut, and Vermont. Her precise words deserve to be remembered forever. Listen carefully, folks. Mr. Chairman, there's citizen opposition to Judge Wesley based on his documented corruption as a New York Court of Appeals judge. May I testify? For Americanism, she gets put in jail. Who should be put in jail? The judge who put her in jail, and his name is Brian Holman. That's who should be in jail. Whereas this simple question was asked by Ms. Sassower as she rose from her seat in the far back of the committee hearing room, where she and other members of the audience were seated, after presiding chairman Senator Saxby Chambliss. Incredibly, the only Senate Judiciary Committee member in attendance on the dais. Get that, folks. Where's the quorum? Where is the quorum? You know what the father said to his son? He says, son, you'll never make president of the United States with your attendance record, but you might make senator. The only Senate Judiciary Committee member in attendance on the dais, had gavelled down an adjournment of the proceeding, without inquiry as to whether any member of the public present wished to be heard. Now that's what you call railroading. And we have a videotape of that. We've shown it to you. He had the gavel down. Then she spoke. Again, I ask you, how can you be accused of disrupting Congress when Congress was not in session? And after Ms. Sassower had patiently listened to 2 hours of speeches in favor of the nominees, I suppose there's not two sides to every question. And whereas we, the undersigned, believe that by making this respectful inquiry, Ms. Sassower was fulfilling a patriotic civic duty, indeed she was for us folks, which was also her duty on behalf of the Center for fulfillment of its noble mission. Nonetheless, within 7 seconds after she spoke those words, Ms. Sassower was forcibly removed from the Senate chamber, handcuffed behind her back, arrested and incarcerated for 21 hours. We've got a great government, but it's been kidnapped by gangsters like these. Why was Sergeant Benyati vindictive? Well, Sergeant Benyati arrested Elena Sassower in the 1996 attempt to protect America from the appointment of a bad judge. And Sergeant Benyati was very, very bad, and Elena filed a complaint against Benyati. So Benyati was having her vengeance on Elena again. Well, folks, it's bedtime. But even though it's very hard for me to read this, and I've asked other people to read it to you who can read better than I can, I declared tonight that I would not go to bed until I at least started reading this to you. So that was we're on the 4th page out of 10. Isn't it beautifully written? Okay. Now the day is over, night is drawing near, shadows of the darkness steal across the sky. Good morning, folks. We are on page 4 of the petition to free Elena Sassower and get her out of prison because she is there because un-Americans locked up an American for trying to protect you from the appointment of a bad judge. Elena Ruth Sassower went to Washington, D.C. to speak against the appointment of a judge named Richard Wesley, who was nominated for the United States Court of Appeals for the Second Circuit in Manhattan. And believe me, he would not be the first bad judge that's been on the Second Circuit. There's a great long line of them. And she did nothing but say that she, as a citizen, opposed the appointment of Richard Wesley. She did this to protect you. You know, what is a country if it doesn't have courts? And you'll go to court, and I hope you don't have to go to court, but when somebody does something bad to you, and you want restitution, and you go to court, you're not going to get justice. All you're going to get is political hack. People standing up one for another, crooks one to another, in self-interest. You are not going to get the Constitution, you're not going to get the statutes, you're not going to get the Federal Rules of Civil Procedure. You're going to get this political slop. So, that's all that Elena did. She stood up and said she opposed the appointment of Richard Wesley, and she was arrested. Is that Americanism? Is that belief and support in the ideals and views and traditions of America? And then she had a bogus trial by a hate judge named Brian Holman, H-O-L-E-M-A-N, and he put her in jail. And he trampled all over your civil rights and everything American and constitutional. And now she's in jail. And her mother, Doris Sassower, wrote this petition, and Doris wants to get her out of jail. I believe the more she stays in jail, the more she makes fools of these fools who put her there. You know, folks, I say again, we have a great government, but it's been kidnapped by a bunch of hoodlums, by a bunch of crooks. Okay, let me continue the petition. We were on page 4. And whereas we find it appalling that She was then taken before a magistrate and charged with the crime of disruption of Congress under D.C. Code Section 503-16b-4. B. It shall be unlawful for any person or group of persons willfully and knowingly to utter loud, threatening, or abusive language, or to engage in any disorderly or disruptive conduct at any place upon the United States Capitol grounds with any Capitol hold buildings with intent to impede, disrupt, or disturb the orderly conduct of any session of Congress or either house thereof, or to orderly conduct within any such buildings of any hearing before or any deliberation of any committee or subcommittee of the Congress or either house thereof. She didn't do any of that. Did she? She didn't do any of that. And Congress was not in session. Saxby Chambliss had put the gavel down. How can you be charged with disruption of Congress if Congress wasn't in session? And whereas by those statutory provisions the government had full awareness that there was no factual basis for charging MSSR with a crime of disruption of Congress, inasmuch as no such crime had been committed by her, and in fact no such crime had occurred. Moreover, the statute in no way defines MSSR's question as prohibited speech. Indeed, nothing in the language of the D.C. statute suggests that it was intended to be applied to congressional committee public hearings, the public being thereby encouraged to believe that its participation is invited. MSSR's question was plainly compatible with the normal activity of the Senate Judiciary Committee, which is to hear and receive information at the public hearing, bearing on the qualifications of presidential judicial nominees under consideration. A D.C. statutory provision deemed to permit criminalizing Mrs. Sassower's respectfully asked question, which sought to express legitimate dissent, is a constitutional anathema and would properly be stricken down by our highest court as a matter of law. Absolutely. And whereas it was readily apparent that Ms. Sassower had no specific intent to impede, disrupt, or disturb orderly conduct before or any deliberations of any committee of the Congress. A person who intends to disrupt Congress does not, as she indisputably did, notify the Senate Judiciary Committee in advance, in writing, of her request to present opposition testimony, and sit through 2 hours of speeches beforehand, waiting for that moment to come. Moreover, by the chairman's announced adjournment, the confirmation hearing was over. When M.S. Sassower arose to make her respectful inquiry, and there were no deliberations of any kind affected. Therefore, the charge of disruption of Congress can only be viewed as a bad faith concoction by the government to protect itself against potential civil liability for her false arrest. Well, it says government, but really what we have here is anti-government. And now we are on page 5. And whereas the criminal charge against Ms. Sassower rested on her assertion of First Amendment free speech rights, all governmental participants, including the court and the prosecuting U.S. attorneys, were charged with the knowledge that her respectfully asked question could not constitutionally be punished as a crime in America. Indeed, in the thousands of free speech cases involving nonviolent speech-related disruption of Congress charges, not no one arrested for speaking of a congressional public hearing has ever served even 1 minute of jail time. And plainly disruptive protesters at recent congressional hearings were not even arrested. Consequently, the ensuing prosecution of Elena in the criminal misdemeanor case of United States of America versus Elena Ruth Sassower, docket number M4113-03, all at taxpayer expense, must be condemned as malicious, discriminatory, and retaliatory. I agree 100%. And whereas United States of America versus Elena Ruth Sassower, number M141303, they didn't even give it a proper case number. M stands for miscellaneous. That's how far out of contact they were with reality. Was tried by D.C. Superior Court Judge Brian F. Holman, a judge himself newly appointed by President Bush at age 46, with no prior political or criminal trial experience, to the D.C. Superior Court, who failed to recuse himself on his own initiative as law and ethical rules required, and thereafter wrongfully denied M.S. Sassower's motion for his recusal on grounds of bias as well as conflict of interest, actual and apparent. And this is page 5 of the petition to free Elena Sassower from jail for going to Washington, D.C. and trying to protect you and trying to prevent the ratification of a nominee for the federal bench named Richard Wesley. And whereas Judge Holman denied Ms. Sassower her pretrial right to discovery of critical documents negating her guilt or mitigating the crime and quashed her subpoenas to compel testimony of material witnesses to the events relating to her arrest and their malicious motivation, he did all that. Anti-Americanism. Predictably, the ensuing trial, railroaded by the judge before Elena had fair opportunity to exercise her appellate right to appeal from such unjust and biased rulings, was, from beginning to end, more a grotesque travesty of justice than a search for the truth, violating Ms. Sassower's fundamental Fifth Amendment due process equal protection right to a fair hearing before an impartial tribunal. All this stuff that you hear and are taught in school, it's rhetoric. When it comes down to the actual court scene, this is what it's like. In every court I've seen, and believe me, I have seen hundreds. I have never found a true judge in the United States District Courts, or in the United States Court of Appeals, or in the United States Supreme Court. And why? Because Congress ratifies these crooks to get into black robes and sit at the bench and unravel America, rob you of America. Repeatedly violated was her Sixth Amendment right to counsel when the judge trampled on her right to defend herself pro se, aborting her opening to the jury when she referred to the events leading up to her arrest and the political motivation therefore, unfairly restricting her cross-examination of prosecuting witnesses, and going so far as to have her locked up during the trial itself without notice or hearing when she sought to present legitimate testimony to show that she had not committed the crime for which he was charged. How's that, Brian Holman? How's that? You call yourself a judge and you call yourself an American? Well, I'm suing you, Brian Holman, for the injury that you did me. When you do things like that, you injure every American there is. And I'm suing you too, Saxby Chambliss, and you, Senate Judiciary Committee. Where was your quorum? The public perception of bias, in actuality of it, was that the result was prefixed from the start. And I've never seen a court scene that wasn't. In the United States court, that wasn't prefixed. That is, conviction of Elena Sassower for a crime the D.C. Capitol Police, the prosecuting attorneys, and the court were fully aware from the outset she did not commit, because no crime ever occurred. Judge Holman's unremitting pattern and practice of vindictive, constitutionally violative conduct before and during trial is epitomized by his post-trial, barbaric June the 28th, 2004 jail sentence. And whereas Judge Holman initially sentenced Ms. Sassower to 3 months in jail, plus 2 days extra to cancel her credit for 2 days of incarceration at the time of her arrest, plus, we're moving on to page 6. The camera is blinking, and he's saying that he needs battery. And so do I. Not alternatively, as allowed by the statute, the maximum of $500 fine and the maximum $250 payment to the Victims of Violent Crimes Act, of which requirement she was never previously informed, payable 30 days from sentence, a sentence on its face vindictive, vicious, and excessive. Moreover, the only victim of a violent crime, yes, was Miss Sassower, who was not the perpetrator, but the one upon whom it was perpetrated. And I have to get up now and give the camera some juice. This is the terrible anti-Americanism perpetrated on Elena Ruth Sassower, who went to Washington, D.C. to protect your rights. So we are back to the talking hat. And as I say, this is page 6. Whereas because Judge Holman gave Ms. Sassower's choice whether she would avoid going to jail on certain orally stated conditions so insupportable by the factual record before him, so disproportionate to the crime for which she was charged, and so humiliating and intrusive on her life and livelihood that they must be read to be believed. And here they are, including 1. This is what Holman offered Sassower. It was brutal as an alternative to going to jail. 1. 2 years probation subject to general conditions severely restricting her personal and professional freedom and burdening her with substantial outlays of time and money, any violation of which would be a basis for a program of graduated sanctions that may include brief periods of residential treatment, During those 2 years of probation, she would also be required to comply with even more oppressive specific conditions. The most glaringly offensive of these are targeting not only Miss Sassower, whom they were designed to silence, but also her employer, the Center for the Judicial Accountability Incorporated. Center for Judicial Accountability Incorporated, which they sought to paralyze. Stay away from and inside the U.S. Capitol complex of 16 national sites, surrounding streets, and 2 nearby mass transit locations. This is Americanism. Cease all electronic, verbal, and other communications with Senator Orrin Hatch, chairman of the Senate Judiciary Committee. Well, what are they there for? Senator Patrick Leahy, ranking Democrat on the committee. Senator Saxby Chambliss, who presided over the committee public hearing, as to Judge Richard Wesley, and other senators and staffers, including as to matters relating to her arrest, her home state's 2 Democratic senators, Clinton and Schumer, who supported Republican Judge Wesley's nomination and were complicit in her arrest. I don't like you. I don't like you, Schumer, and I don't like you, Clinton, because you're not an American. You are trying to rob us of America. Keep daily time records of all her activities as coordinator of the Center for Judicial Accountability in tenths of an hour. That is, every 6 minutes. Do 100 hours of community service, 100 in the District of Columbia. Under no circumstances will the Center for Judicial Accountability work or related activities satisfy this requirement. Okay. Do you think she said yes to this? Stay tuned. Submit to substance abuse, medical, and mental health testing, as well as anger management, therapy. Well, let me tell you, the people who put her in jail should submit to that. They act to me like they're on dope, or they act to me like they're drunk. They act to me, certainly, as well. They need anger management. Prepare and forward letters of apology to Senators Hatch, Leahy, Chambliss, Schumer, Clinton, and to Judge Wesley, which state the fact of your conviction and remorse for any inconvenience caused by your actions. As to this latter condition, after Ms. Sassower managed to, page 6, not alternatively, as allowed by the statute, the maximum of $500 fine and the maximum $250 payment to the Victims of Violent Crimes Act, of which requirement she was never previously informed. This is so... I have lost my place. We will continue on page 7. Who wouldn't lose one's place in this morass? Let me just go back and pick up page 6 where and remorse for any inconvenience caused by your actions. As to this latter condition, after Ms. Sassower managed to interject, I am not remorseful, and I will not lie. The judge continued, ignoring Ms. Sassower's words, spoken in her own pro se defense, to direct that copies of the letters of apology must be sent to me as presiding judge. What an egotist, a maniac egotist. This is what they do. They lie. And then it goes out to the public. and the public believes it. It's quarter after the hour, and every quarter after we rejoice. Now it's rather macabre to rejoice that Elena Sassower was put through all this, but I do rejoice. She is sacrificing her life to show you how bad things have become in America, to show you that we have a great government, but it has been kidnapped by gangsters. This is a miserable thing to rejoice about, but all things work for good for those who work for God. I believe that Elena Sassower is tremendously honored. This is a great call. This is a great call. This is as great a call as any American hero that I can ever think of. And I believe that she's doing it brilliantly, and her mother along with her. So, I'm going to read you the rest of page 7. We have page 7, we have page 8, we have page 9, and we have page 10. Doris. Recounting this extremely complicated and dirty violation of human rights in the United States of America, which has been kidnapped. Page 7. Whereas, again, when Miss Sassower attempted to assert her right not to be coerced into perjuring herself, stating, "They will not be sent because they will not be written." Judge Holman, instead of acknowledging her so expressed objection to the condition, cut her off, telling her to be quiet, continuing to deny her her right, both as defendant and as her own attorney, acting pro se, to be heard with respect to her sentence. And whereas we find it reprehensible that when Miss Sassower did not grovel or grasp at his offer, Judge Holman advised her incorrectly that in this jurisdiction, when a convicted criminal is given probation, they must accept the probation. He then went on to say, "Miss Sassower, the answer is either yes or no. Do you accept the terms of the probation as I have stated them to you?" Repeating the question. When she responded by requesting a stay of sentence pending her appeal, the judge ignored her question, again repeating his demand for a yes or no answer, demanding to know, do you accept the conditions of your probation? Whereas, notwithstanding this improper political, whereas, notwithstanding this improper judicial coercion to compel an immediate yes answer, rather than affording her reasonable time to consider the propriety and ramifications of the answer sought by the court, so as to allow her to confer with counsel, family members, friends, and supporters before responding. And whereas, when Miss Sassower gave a principled no answer to his high-pressured question, Judge Holman punished her for her candor and honesty in exercising the very choice he had expressly offered her. That very instant, without prior warning as to his intentions or opportunity to be heard, without any factual finding that she was a danger or flight risk, without citation of legal authority, and in trial disregard of the recommendation of the prosecuting U.S. attorneys and the court's own probation services pre-sentence report that there be no jail time. The U.S. attorney and the probation department stated that there should be no jail time. No jail time. Even as they recognized her as not remorseful, Judge Holman, in an obvious fit of temper at not getting his recognized and not getting his way, not only capriciously doubled her sentence to the maximum as foresaid, in addition to his directed total $500 fine and $250 payment to the crimes victims of violent crimes, the court's Victims of Violent Crimes Fund, but directed her incarceration forthwith. At the same time, he precluded her from saying one word after her so-called doubled sentence by directing her to be immediately served, seized upon, and removed by the U.S. Marshals. He's a sick man. Is he fit to be a judge? No, Congress, he's another one of your appointments, another one of your ratifications. Seized upon and removed by the U.S. Marshals, all in violation of her Fifth Amendment due process, equal protection rights, as well as her Sixth Amendment right to be protected from cruel and inhuman punishments and excessive fines. As if that were not enough, in concluding the proceeding, when Miss Sassower was already precluded from uttering a single word, the judge sadistically, and that is a perfect word for this man, Brian Holman, rubbed salt into her open wounds by falsely characterizing his conditional offer to release Miss Sassower as a beneficial circumstance for her, and so reported by press in attendance, which only her pride had kept her from accepting. That's insane. That's mentally unbalanced. So as thereby to imply that her guilt, rather than the innocence, was the true basis for her rejection. I'd like to see the day, Brian Holman, when you stand before a real judge and you pay for what you have done to this woman. So this is page 8. So we're going to take a break. Thank you, Elena Ruth Sassower. Thank you. Folks, this is Partnership Day. Yes, 6 months ago, on February the 14th, this is September the 14th, the realization came that you and God are partners. You are partners and you work together to keep this universe perfect. So we celebrate Partnership Day with great joy. And Elena, Ruth Sassa, is a partner with God, working to keep this universe perfect. We are on page what? 8? Yes, we'll do 8, 9, and 10, and that will finish it. This is a petition to free Elena Ruth Sassauer from jail. She was wrongly charged, she was wrongly tried, and she was wrongly sentenced, and she was wrongly incarcerated. So her mother wants her out of jail, and this petition is written by her mother, and it's supremely written. Whereas, following Miss Sassauer's urged unjust and unlawful incarceration, on motion of the Center for Judicial Accountability Incorporated, to the D.C. Superior Court Chief Judge Rufus King III, requested a copy of the audio tape of the sentencing proceeding by reason of discrepancies in and omission of material facts in the official court transcript of the June 28, 2004 sentencing proceeding, certified on June the 30th, 2004. This goes on all of the time. They tamper with the record. They belong in jail. They don't let you videotape it. It should have been videotaped, like Rodney King. The whole country should have seen actually what happened, instead of their lies and their cover-ups. After the chief judge denying without reasons the center's audio tape motion, an amended transcript, this one certified July the 15th, 2004, was transmitted from the court without explanation relating to the identical June the 28th, 2004 sentencing proceeding. Such contained two additional pages omitted from the original. Such document revealed that further judicial misconduct had taken place, which the original transcript had wholly concealed and covered up, and believe me, there's a whole lot more that has been concealed and covered up. But prima facie, this is enough to put Brian Holman in jail. Impeach, fined, and jailed Brian Holman. Whereas, ready comparison of the two transcripts is accessible on the Center for Judicial Accountability website homepage by checking onto, listen folks, www.judgewatch.org and look under latest news. www.judgewatch.org. Checking onto the tale of two transcripts, starkly exposed by the amended transcript, was the willfully suppressed fact that following the announcement as recorded in the original transcript that the, quote, proceedings were concluded, unquote, and after the press and public left the courtroom, having witnessed Miss Sassauer hauled out of the courtroom in handcuffs, Judge Holman, once again, without notice or opportunity to be heard by the defendant, unlawfully reconvened the court that day at a time unspecified so as to have Miss Sassauer brought back from jail to come before him once more. The reason revealed in the amended transcript was that he had failed to read her appellate rights. Great judge, isn't he? Great job, Congress. Oh, you did a great job, Congress, in ratifying this judge. Wonderful job, Congress. Wonderful job, Senate Judiciary Committee. Wonderful job, Orrin Hatch. Wonderful job, Patrick Leahy. Wonderful, wonderful job. Saxby Chambliss. You really are standing up for America, aren't you? You really are true Americans and true patriots, doing your duty, aren't you? Whereas the amended transcript materially altered the final words on the last page in the original transcript preceding the two omitted pages, which reflected that the proceedings were concluded so as to make it appear falsely that the court had gone into a brief recess, as if expecting to resume it. In that way, Judge Holman thought to justify his having dispensed with the due process and public trial required under the Fifth and Sixth Amendments for convening such post-sentence proceeding, after the sentencing proceeding had been officially recorded as having been concluded. It's very complicated for Doris Sassower, Elena's mother, to impart this to you, but she's doing a great job, and you know what it all adds up to. Robbing you of America. And what are you going to do about it? What are we going to do about it? Remember, we're partners with God, okay? Remember, we are partners with God. Whereas the amended transcripts further exposes the fact that Judge Holman's denied Ms. Sassower's post-sentence request for a stay, pending her appeal, this time giving a reason for his denial, however, one that was legally impermissible, said Judge Holman. To do so would be to show you favorable treatment that I have not, page 9 out of 10, in the past shown any other convicted criminal defendant in this courtroom. And I won't start that practice now. Oh, holy and mighty Judge Holman, we found out about you that you started giving orders before you were ordained. Okay, before you had the authority. George McDermott has found that out. The dates that you were installed and the dates that you sat on the bench and gave orders without authority. Maybe we can get you in jail, Judge Holman. By that clear admission in a general bias on the subject of stays, Judge Holman vitiated his sentence so as to render it null and void. Doris is saying that when he did that, he vitiated his sentencing of Elena and made it null and void. As a matter of law, on that ground alone, this is over and beyond his denial of due process and other judicial misconduct in not affording her the right to say even one word in her own defense by directing her to be once again in this second sentencing proceeding immediately seized upon and removed by the U.S. Marshals, whereupon the amended transcript records the proceedings were concluded. Judge Holman thereby epitomized his judicial misconduct from the beginning of the case to the bitter end. Okay, I'm going to write a judicial misconduct and disability complaint about Judge Holman. That is Title 28, the United States Code, Section 352. And Congress did this in November of 2002. I don't have to have standing. That is, I don't have to be a plaintiff or a defendant or a party to the action. It doesn't cost any money. I just have to contain it to 5 pages. And I will quote this. And this is my reason. And this Title 28 says, Section 352 says, conduct prejudicial to the effective and efficacious administration of the business of the courts. If you don't see that here, you'll never see it anywhere. Isn't this the prototype of conduct prejudicial to the effective and efficacious administration of the courts? So in addition to suing Judge Holman, I am going to file a judicial misconduct and disability complaint. And where do you file that? Well, since he's in the D.C. Superior Court, he's in the jurisdiction of the D.C. United States Court of Appeals, and I will file it there. And let me tell you, D.C. TV, you had better cablecast this program. And I don't want any more of your foolish excuses, like the program didn't have any credits. That happens to be editorial control, which is against federal law and municipal law, and I would assume D.C. law. So you better put these happenings on the TV in the District of Columbia. They will go on the internet, which far surpasses you, D.C. TV. But if you don't put them on, and if you don't publicize, if you don't cablecast these programs on Ruth Elena Sassauer, you're going to be sued. You're going to be sued for the third time. And this time you're not going to be sued in the District of Columbia, because this is a civil rights matter, and any federal court in the United States has jurisdiction over civil rights. So you're a goner, D.C. TV, if you do not cablecast this. Also, it should be on Maryland public access, on A Chat with Glendora, which is on every Monday night at 7 p.m. And thank you, Maryland Public Access. So Judge Holman thereby epitomized his judicial misconduct from the beginning of the case to the bitter end. Whereas in the state of the record before him, Judge Holman's denial of a stay pending appeal with no findings whatever to support such, and his incarceration forthwith order without any bail set cruelly and inhumanely prevented her, Elena, from returning to New York so as to permit her to put her affairs in order before commencing her 6-month jail sentence, flouted her constitutional rights and customary practice in nonviolent, non-felony criminal matters, supported by recommendation of both the prosecuting U.S. Attorney and the Court Services pre-sentencing report, that there be no jail time. This was, you know what this was? This is what you call a personal frolic. Holman was having a personal frolic. Whereas such unconstitutional, indefensible, totally outrageous judicial misconduct is why innocent, unjustly accused, and unfairly convicted criminal defendant Elena Ruth Sassauer is now D.C. prisoner number 301-340, and defendants like her similarly convicted as a result of police, prosecutorial, and judicial misconduct are overcrowding jails all over the country. And Ethan Book, who was the same victim of this kind of thing, was sent to jail for a year by Governor Rowland of the state of Connecticut because he was blowing the whistle on the relationship of the Bridgeport Development Authority to loaning Enron something like, oh, it was a huge amount of money. Huge amount of money. This was before Enron was caught. So the overcrowding jails all over the country, and Ethan would say that 25% of the people in jail are innocent. So Doris is hitting the nail on the head here. According to a recently released Justice Department report, there are now nearly 6.9 million persons in jail or under control of the criminal justice system, including probation and parole. This new high for America is not a record of which Americans can be proud. Well, I think there's 6.9 million judges, U.S. attorneys, U.S. marshals, and FBI agents who should be in jail. Now, therefore, we, the undersigned, hereby declare our love and support of Elena Ruth Sassower, whose example as a prisoner of conscience we respect and admire. As the symbol and leader of a new judicial reform movement, she provides inspiration and hope to judicial victims all across our land. We respectively, individually and collectively, hereby condemn the government abominations. Now this again is the anti-government. Abominations and mistreatment of her as set forth here and above, and do by this petition protest the same, beseeching, imploring, and praying that the D.C. Court of Appeals free her now for a crime she did not commit, and in fact a crime that never occurred, for which she was unjustly doomed to be in prison since beginning of summer until the beginning of winter. I pledge. Page 10, last page. We do hereby respectfully join in this petition so as most fervently and sincerely to urge that the D.C. Court of Appeals issue an order freeing Elena now by granting her application for a stay of sentence pending appeal, and by summarily, well, it's only a right, she's only guaranteed that by the Constitution of the United States, and by summarily granting her appeal, absolving her from her wrongful conviction and sentence for the crime of disruption of Congress. How can you disrupt Congress if it's not in session? The gavel went down, Congress was not in session. So as thereby to lose no time in resurrecting our mortally wounded Bill of Rights, not only for Elena, but for the Bill of Rights and for you, as shown by the record to have been egregiously violated by the lower court judge. This is vital so as to evidence the necessary and proper recognition by the D.C. Court of Appeals itself without any further delays of the horrendous wrong done her and the gross miscarriage of justice that has occurred to the eternal shame of this country, here and abroad, and you people on the internet, worldwide. When you hear America bragging about human rights, just remember that this is going on every day. And we, the undersigned, demand full and complete investigation into and public hearings by all three branches of government so as to make known the true facts surrounding the aforesaid governmental abuses that have resulted in unjust denial and deprivation of Ms. Sassower's constitutionally guaranteed civil rights as a result of executive, legislative, and judicial misconduct, including the gravely serious crimes that apparently have been committed by the D.C. Superior Court in connection therewith, and the removal forthwith of D.C. Superior Court Judge Brian F. Holman, and removal, not just removal, but removal into jail, upon a finding that he is guilty of judicial misconduct immediately threatening the public interest. Indeed he is. And finally, we, the undersigned, wish to let it be known to the entire world that the American public will not stand for any form of tyranny in its own country, be it presidential, legislative, or judicial. Click here to sign the petition. Go to the website, folks. You can also call me up, and I will get a petition for you to sign. But on the Judge Watch, on the internet, www.judgewatch.org, judgewatch.org. You can sign this petition. And can you read this okay? You can read a whole lot better than I can. It was awfully hard, folks, for me to read this. It was hard for me to see it. And I asked somebody else to read it, and they wouldn't do it. In fact, this person said, "Oh, there's a protocol that has to be followed." And I said, "Yeah, there is a protocol that has to be followed. It's called of the people, by the people, and for the people. That's the protocol that has to be followed." I want you to know also that George McDermott went to this trial, and we reported upon that earlier to you, way back in May. We had several programs on that. George McDermott reported to A Chat with Glendora what he saw at that trial. And then we have the interview of, or the roundtable discussion by George McDermott and Elena Sassower, fresh out of that court. We have that. And that's on the internet. You can see that anytime. What's Glendora's site? www.achatwithglendora.com, and I put an index up there, folks, for you to follow. The index for the last 2 weeks has gone out, and I'm starting a new index, but this is the way it goes. It tells you what the program number is, okay, and then it tells you the people who are on it, so that you can find it, and it's up there day and night. As you can see, currently I'm doing Sassower, and it's bringing it up to program 3887, 5th edition. And it's just coming to an end. It's at 2 hours and 28 minutes, 29. So let me bow out. We love you, folks, and remember, you're partners with God. This is Partnership Day, from February the 14th, Valentine's Day, to September the 14th. Do you hear the cricket? Cricket, I opened the door. Will you please go out? Will you please go out? Folks, I have another degenerate report about, or rather report of degeneracy about Brooklyn. Brooklyn Public Access, called BCAT. They have a ignorant policy of not cable casting a VHS tape. Now, Glendora's on 45 TV stations, and there's no reason in the world they cannot cable cast on a regular VHS tape. No reason in the world. And they say, "Oh, it won't play in our machines." Well, I know machines, and I know that's not true. That any super VHS machine will play a VHS, a regular VHS. Behind this is Kareem Bland. And that's one offense, okay? Now here's the next offense. So they haven't been cable casting A Chat with Glendora. All of the tapes that have come in, they haven't cable cast. They've been playing the same one over and over again. That's number 2 offense. What's number 3? They never told me. I find out this yesterday. This has been going on for months and months and months. Now, I talked to Joan Myers about it. I talked to Kareem Bland about it. I like talking to Leon. I like him. He tells me all kinds of things that are interesting. So there are 3 ridiculous and injurious offenses against public access. BCAT, what is the matter with you? Why can you not run a public access operation? This I give you credit for, that you stream onto the internet all of the public access programs from 9 a.m. to 1 a.m. That we give you credit for. But as far as daily, sensible, intelligent operation of a public access facility, you have got to be at the bottom of the pit, along with a few others. So you get an E. You get an E. That is what your report card is, an E. Now they're coming up with a crazy renewal in September, and it has to be in Halloween. And we got to go bother Jackie Rickman again. So, Brooklyn Community Access Television, you are a failure. The next legal paper is from the United States District Court for Illinois, Eastern Illinois or Northern Illinois or whatever. Anyway, it's Chicago. And I just want to read to you the slop that they put out and get paid $140,000 plus a year. United States District Court, Northern District of Illinois, Office of the Clerk, Michael W. Dobbins, Clerk. Glendora, Post Office Box 124, Ghent, New York, 12075, case number 104, Civ 3432, titled Glendora versus Lasnik. Lasnik is a bad judge in Washington State. Another bad U.S. District Judge. There's no other kind. Assigned Judge, Honorable Charles R. Norgal, Sr. Well, let me just cross out that honorable. Minute order of August 27th, 04, by Honorable Charles R. Norgal. Twice he's not honorable. Senior. On August the 19th, 04, the court received an unsolicited ex parte communication from the plaintiff. See attached. The clerk shall cause the attached unsolicited ex parte communication from the plaintiff to be filed and made part of the record in case number 4C3432 and mailed notice. Oh, thank you. Thank you. At least, Norgal, you're one tiny step above a whole flock of United States district judges and clerks who will say, case closed, can't file any papers after the case is closed. This is a pet violation of Carol Allman, the evil Eastern District of New York, the clerk there, Robert Heineman, and the deputy clerk there, Ralph Vega. At least you're one step above them. This docket entry was made by the clerk on August the 30th, 2004. And attention, this notice is being sent pursuant to Rule 77D of the Federal Rules of Civil Procedure, or Rule 49C of the Federal Rules of Criminal Procedure. It was generated by ICMS, the automated docketing system used to maintain the civil and criminal dockets of this district. If a minute order or other document is enclosed, please refer to it for additional information. For scheduled events, motion practices, recent opinions, and other information, visit our website at www.Illinois, it must be ILND, oh yeah, Illinois Northern District, .uscourts.gov. Check our website for CourtWeb, a concise listing of rulings by judges. If I were you, I wouldn't waste your time. Check for rulings on noticed motions. Also subscribe to Court Watch, a free service to receive email notification of CourtWeb postings. I wouldn't bother if I were you. To apply for a PACER account, call 1-800-676-6856. Well, now, it's interesting to me that they purport to, well, first of all, let me take care of some more of their housework. This thing, I really can't see that it says anything, can you? I just don't see anything, except maybe a signature. Now, a signature has to be attached to an order. This is a crazy way they have of doing it, you know, these computer-generated clerk papers. Okay, now, they enclose, purportedly, a copy of this paper that Glendora filed. This paper was read carefully to you a month ago, so we will not repeat that. It's a copy of the so-called order. And here is the proof that it has been filed. And what the paper starts out with is, this is slop, this is trivial, frivolous, conclusory, vexatious, and an insult to the United States of America. This is criminal, 18 U.S. Code, Section 1001, misrepresentation. Norgal and law clerk should be fined and jailed. Okay, so they filed it. Got to give them credit for that. Now this is interesting. This is page 3 or 4 of what Glendora sent. And they claim that this is the entire paper. Well, it is not. There are missing pages. And then, instead of sending me a paper of what I wrote, they send me another copy of this thing that I just read you. All right, Norgal, let me give you your number on the internet. I'll have to go into the office, folks, and get it. Hold on. And that is not it either. Your estimated show number is 3888, edition 6. And when will it be on the internet? I would say first week of October. That's an estimate. We're getting a little better at these estimates because we're learning how to do this a little better. So I think we're a little closer with this estimate than we were your last one. This is a script. Headshot of Glendora. Glendora. Folks, turn to the person next to you and say, God loves you. Here's today's jokes. Did you hear about the Czechoslovakian trampoline team? They call themselves the Bouncing Czechs. A woman went into the post office and asked for $50 worth of stamps. The clerk says, what denomination? She said, Baptist. How can it be that so many Americans don't vote? It's because under the Republicans you can't earn your keep, and under the Democrats you can't keep what you earn. Why do they call it take-home pay? You're too embarrassed to take it anywhere else. And the judge said to the caddy, "Caddy, why do you keep looking at your watch?" And the caddy says, "Oh, no, sir, this isn't a watch, it's a compass." Folks, what do you call a miniature guppy? A microfiche. The lawyer said to the judge, "I want a new trial on the basis of new evidence." The judge says, "What's the new evidence?" And the lawyer says, "I just found out my client has another $3,000. This is Glendora, a cheerful look at life. Keep the courage flaming. And this 30 seconds of good cheer is brought to you by whom? Lord, dismiss us with thy blessing. Fill our hearts with joy and peace. Let us each thy love possessing. Triumph in redeeming grace. Oh, refresh us, oh, refresh us. Traveling through this wilderness. This is Partnership Day. We celebrate our partnership with God. Folks, this is a judicial misconduct and disability complaint against Charles R. Norgal, Sr., United States District Judge in the United States District Court in Chicago. And it starts with a statement of facts. This is a judicial misconduct and disability complaint against Charles R. Norgal, Sr., United States District Judge, Chicago. Complaint is pursuant to 28 U.S. Code Section 352 of November 2002. Norgal does not know the law and does not enforce the law. This is the minimum the public can expect of a United States District Judge. They make $140,000 a year plus. The public can expect of a U.S. District Judge. He never should have been nominated. He never should have been ratified. The law, the two exhibits attached tell why. Those two exhibits are: one, Glendora's Rule 60B motion for relief from his order, and two, when he denied it, Glendora's refutation. And that was presented to you this morning, that it was filed in the court. Glendora has read his record on the internet where the world can judge this judge. Further, she has read the record on TV. And this tells about the 45 TV stations that a chat with Glendora is on. Glendora is suing Norgal in her Omnibus 23 lawsuit, now being written, soon to be served. Shall we appeal Norgal to the 7th Circuit, folks, or to the internet? World Wide Web. What do you say? Appeal him to the 7th Circuit or to the World Wide Web? Well, we chose www. The appeal would expose 3 more bad federal judges. They would have to be sued, and Glendora is running out of federal courts in which to sue. She has been in practically all of them. An appeal costs $105, and I say $105, not $255, and $50 estimated to print, post, and travel. The money we hope is more effectively spent on the internet, and let the world judge. Norgal's conduct is prejudicial to the effective and efficacious administration of the business of the courts, and the business of the courts is justice. Well, the U.S. courts have been out of business for a long time. Glendora cannot see how much longer people will buy your product. It is no good. Yours in truth and an amor patriae, Glendora. And on the web, number 3888, 6th edition by October 10th. And what opus is this? I'm guessing that it's about opus 1202. We're celebrating the 4,000th TV show. I wonder if we should celebrate the 1200th legal paper. The cost of it was about a couple dollars, and the hours that it took were about one. And this is Partnership Day. You and the Lord are partnerships. Folks, this is Mary, George McDermott's daughter. She's a pleasure to talk to.
5600 Cherry Wood Lane, and I'm the Greenbelt. I need these zip codes. Give me 1 second. I'm on hard to look it up somewhere. You're so smart. Gotta be a little bit. Oh, gosh, something's here on them. You want me to call you back? Okay, you can read it on my own.
She's going to get me.
That'd be great.
Yeah, she's going to get me the address for Peter James City, whom I'm suing. Over here we have in process, and it's coming along very, very well. We have in process Omnibus 23, and we have written the complaint against Chambliss, the U.S. Senate Judiciary Committee, and Brian Holman. And now we're just about to write the complaint, and I've written the complaint against Peter J. Massetti, who put a pro se in jail because he handed in papers pro se. A terrible violation of constitutional right. And then the next one is William Donaldson and the chairman, who is the chairman of the Securities Exchange Commission. And who is after that? Oh, Heavy Cam, the U.S. Attorney in Nebraska, and Johnson. And after that is Fox, a United States District Judge in North Carolina, for dismissing a chat with Glendora. Excuse me, for dismissing Omnibus 22 with no statutory authority. Hopewell Reformed Church, Dutchess County.
Church that was having a
too.
Bye-bye.
Bye. The superintendent of schools told the teachers and the principals that our student body suffers from seven dwarf syndrome. Every seventh kid is dopey.
That's a good one. Yeah, I know you got all the other ones too, you know?
Yeah.
It doesn't, each one has its own little personality there.
This is a report to you of a landlord-tenant case. These are where it's going. Mary Lou Kirsten, President, Columbia Green Board of Realtors, Hudson. Roberta Nicholson, Executive Vice President, same. Niersbach, National Association of Realtors, Chicago. Executive Vice President, National Association of Realtors. Jan H. Primadori, Deputy Administrative Judge for the State of New York for the courts outside of New York County. Jonathan D. Nichols, Columbia County Court. Jonathan Littman, he's the head judge of the administration of New York State Courts, specializing in those in Manhattan and Queens, the County of New York. Judith Kay, and I do mean Judith Kay, and not some underling. Preferred Country Properties, a bad landlord outfit in Chatham. That would be Natalia, Lydia, mother, father, Carlos. Clerk of the Court, Chatham Village Court, that would be Mrs. George Dixon, wife of the judge of the court. The Village of Chatham and the Police Department. James Kleinbaum, lawyer for Natalia, Preferred Country Properties. Administrative Judge for the Third Department, State of New York, Supreme Court, George Ceresia. Well, not only the Supreme Court, but all courts in the Third Department. Robert Tembekian, who is the I don't know what you would call leader, director, whatever, of the New York State Commission on Judicial Conduct. You are guaranteed to be protected against bad judges. So, you're looking at about 8 hours work and about $12 to print, post, and travel to serve. And this is what I'm going to read you. State of New York, County Court, County of Columbia. Glendora, plaintiff appellant. Against Preferred Country Properties. Decision in order. Preferred Country Properties is the defendant, and the appellee, and Glendora is the plaintiff and the appellant. And this is before Jonathan D. Nichols in the county court, County of Columbia. Rejoice, ye pure in heart, rejoice, give thanks and sing. Your festal banner raised on high, the cross of Christ your King. Rejoice, 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 give thanks and sing. Appellant appeals, say more, from a decision and order rendered in the small claims part of the Justice Court of the Village of Chatham, J. Dixon, on April the 13th, 2004. Preliminarily, it is observed that by decision and order dated March the 20th, 2004, this court, meaning the Columbia County Court, Nichols, Clark, dismissed the appellant's appeal without prejudice on the ground that it was filed prematurely. However, appellant subsequently advised the court that the papers referenced in the May 20th, 2004 decision and order did not constitute a notice of appeal, and therefore filed a notice of appeal with the court on May the 29th, that's Bob Hope's birthday, 2004. Respondent offered no objection to the appellant's filing as the notice of appeal as aforesaid. Therefore, it is apparent that the court misapprehended the nature of the papers filed by the appellant referenced in the May 20th, 2004 decision and order. Therefore, that decision and order is hereby vacated nunc pro tunc. Footnote. Although respondent's brief references another appeal involving these parties, that matter is not before this court at this time. Reply brief. Appellant's brief, appellee's brief, and appellant's reply brief, 3 papers. The pertinent facts as to the instant matter are relatively uncomplicated. On March the 23rd, 2004, appellant filed a small claims action against the respondent, and that would be Natalia and Preferred Country Properties, in conformity with Uniform Justice Court Act, UCJA, Section 1803. The clerk of the village court prepared and mailed a notice of small claims to the respondent on April the 13th, 2004. Appellant and respondent appeared before the village court. At that time, appellant filed a document entitled Glendora ad damnum, purporting to set forth her particular damages relative to her small claim. Thereafter, on motion by respondent's attorney, the village justice dismissed the appellant's claim, finding that the claim was improperly titled as to defendants, and there was nothing legibly filed to make a determination for alleged damages. Based upon the aforesaid, it is this court's determination that the village court erred. That's the word you're looking for. The village court erred. George C. Dixon erred in dismissing appellant's claim. The small claim court is designed to allow unrepresented individuals, untutored in the formalities of the law, to pursue claims in a simplified setting, free from the technical requirements that animate, my, what a good word, more traditional civil courts. In that regard, UCJA, Uniform Justice Court Act, Section 1804, explicitly states that small claims courts shall not be bound by statutory provisions or rules of practice, procedure, pleading, or evidence. Indeed, the statutory mechanism for commencing a small claims action evidences the unique, relaxed nature of the small claims court, inasmuch as it dispenses with the need for a summons and a complaint, as the court clerk instead prepares a notice containing a statement of the nature of the claim and thereafter mails said statement to the defendant. See the Uniform Court Justice Act 1803 at 22 New York Code Rules and Regulations 214. There's a footnote over here. The use of the singular tense will be addressed herein. You're up to page 3, you have 4, 5, 6, and 7, in case you want to go to another channel. I am adamant about reporting this to you, because this kind of corruption in a court and in an attorney and in a landlord happens repetitively in all over. It's a ring, and this is what makes people homeless. And I want you to know that you do not have to take this. You do not have to take this. You can stand up and you can protect yourself. And this tells you a lot about how to do it. The decision of the court goes on. In light of the statutorily mandated informal nature of the small claims court, the village court erroneously, that's the word you're looking for, erroneously, George C. Dixon erroneously held appellant to an impermissibly high standard relative to pleading requirements by granting respondents' motion to dismiss rather than proceedings with the small claims action. It is readily apparent that the appellant's statement regarding the nature of her claim was decidedly uninformative, inasmuch as it merely stated that she had been damaged by the respondent, that would be Nasty Natalia and Preferred Country Properties, in the amount of $3,000, and that the nature of the claim was personal, quote unquote. However, in that appellant was not the actual draftsperson of the statement, meaning that George Dixon's wife was. See Uniform Justice Court Act, Section 1803, it would have been appropriate for the court to enable her, Glendora, to flesh out the details of the claim rather than dismissing the same due to the deficiencies therein, especially in light of Uniform Justice Court Act Sections 1804's declaration that small claims courts need not be bound by statutory provisions or rules of pleading. This is very, very well written. It's written by John Clark. As set forth supra, appellant filed an ad hominem relative to her small claim in April the 13th, 2004, setting forth details of her claim. The village court should have considered the appellant's small claim statement in conjunction with the ad hominem in determining facial sufficiency upon respondent's motion to dismiss. Upon a motion to dismiss a pleading for, just a second folks, let me get this footnote. I think it's too long, the footnote. I'll have to reread it to you later. Upon a motion to dismiss a pleading for facially insufficient, see, the pleading is to be liberally construed. Section CPLR, CPLR, that's Civil Practice Laws and Rules in the state of New York. 3013. Somebody versus D'Agostino and Servino versus Salisbury. Further, all evidentiary averments contained in a pleading are deemed true for the purpose of determining the adequacy thereof. That's right. The court just automatically has to assume it's true, whatever the plaintiff says. Then, if it isn't true, that will surface. That's Williams versus Williams. Finally, evidentiary submissions of the moving party, if needed any, may not inform the court's determination in any manner. The pleading at issue is the exclusive piece of evidence properly considered by the court in determining facial sufficiency. That's Ravello versus Orofino. I have to go back now and read you this footnote. We're reading on page 4 out of 6. The appropriateness of considering the appellant's ad hominem is demonstrated upon consideration of a number of factors. In this regard, the appellant, that's Glendora, submitted the ad hominem on April the 13th, 2004, the earliest date available to her for such purpose. See Uniform Justice Court Act, Section 1803. A. Disallowing the service of any pleading other than the statement of the cause of action, absent special order of the court. In addition, the ad hominem was filed within the time period set forth by the Civil Practice Law and Rules for filing amended and or supplemental pleadings without leave. See Civil Practice Laws and Rules 3025A. Finally, as indicated by the village court in its return, the ad hominem is related to a separate action brought by the respondent against Glendora. As such, the village court had the authority to consider the ad hominem as a counterclaim and entertain appellant's claim on April the 13th, 2004, or adjourn the proceeding at respondent's request. See Title 22 New York Code Rules and Regulations, Section 3214. In any event, the standard to be employed regarding the facial sufficiency of the ad dominum is the same regardless of whether that document is viewed as an initiating pleading or a counterclaim. Facial sufficiency. I've gone all my life without facial sufficiency. Reviewing appellant's ad dominum in light of the principles enunciated supra, this court finds that it is facially sufficient. The averments animating the document were sufficient to place respondent on notice that appellant sought damages for, inter alia, the return of a security deposit, damage to personal property, and other related expenditures. Therefore, the village court's dismissal of the claim for facial insufficiency was inconsistent with both statutory authority, Civil Practice Laws and Rules, Section 3013, and principles of substantial justice, Village of Castleton-on-Hudson versus Pillsworth. Notwithstanding the aforesaid, this court affirms the village court's dismissal of appellant's claim as it relates to the following named defendants: Nasty Natalia, Brat's sister Lydia, Mother Marie, Father, and Brother Carlos. The applicable rules of procedural require that a small claims court litigant provide the clerk of the court with the names of the defendants in the action. Title 22, New York Code, Rules and Regulations, Section 214. That requirement is entirely consistent with the civil practice law and rules requirements relative to papers generally. See CPLR Rule 2101 and CPLR Rule 1024. The names employed by the appellant as set forth above are not proper names, and as such their use fails to comply with the statutes cited supra. Although the small claims court is relaxed in terms of pleadings, appellant's use of improper names in a court caption is antithetical to the purpose of captioning initiating papers. That is, to give notice to the parties, and as such is inconsistent with the notice requirements set forth in the Civil Practice Laws and Rules and the Uniform Justice Court Act. Finally, a review of the small claims notice reveals that it was mailed only to the address of preferred country properties. While said mailing clearly constituted proper service on that particular entity, it was ineffective as to gaining jurisdiction over individual persons. Well, I paid $20 to a young man to serve all of those people: Nasty Natalia, Brat Sister Lydia, Mother Marie, Father, Brother Carlos, and preferred country properties. And I have supplied the county court with the affidavit of service. That's one thing. You understand that I did have jurisdiction. I did give the court jurisdiction over all of those names. Nasty Natalia, Brat Sister Lydia, and so forth through Brother Carlos. But we're going to let them have that. A further thing to say about it is that, remember Glendora versus Bruiser Ken? The insane Pinkerton who beat up Franklin and myself in the federal court in the Eastern District of New York, Suffolk County, you remember that? That was Glendora versus Bruiser Ken, and inflicted bruises all over us. Okay, I say that they're wrong about this.